I'm Matthew Gough, I'm a partner at Eversheds, and I'm here today to tell you about the new European Consumer Rights Directive. The official reference is Directive 2011-83 EU on consumer rights, and it was published by the European Parliament on the 25th of October 2011. European member states have to implement this into national laws by the 13th of December 2013. It has to be a law by 13th of June 2014. What I'm going to look at today are the key changes it will make in European law and the effects it will have on the member states. Because presently we have 27 member states and all of them have their own consumer laws. What this directive is hoping to do is harmonise that consumer law into one consumer law applied across the member states so that people know what their rights are wherever they do business in Europe. And the whole point is to encourage cross-border trade so that when people use the internet in France to buy goods from Germany, they can be sure that they're having the same protection as if they were buying goods by a French company in their own native country. And what the change in law does, it brings in 9 key changes to the existing position. The first key change is the cooling off period. If people buy goods over the internet or through a sale outside of the trader's premises, they will now have 14 days in which to change their mind. Previously, for example, in English law, it was 7 days, but now across the whole of Europe, this will be a 14-day standard period. If the trader fails to tell the consumer about this right, then the consumer will have 12 months in which to withdraw. So there'll clearly be an encouragement for the trader to let the consumer know about this new 14-day cooling off period. The second change is the importance of pre-contractual information. What the directive demands is a clear set of information before the contract is formed, setting out the main characteristics of the product, the geographical address of the trader, and the identity of the trader and any delivery charges, in an attempt to make it very fair across Europe that wherever you're making a purchase, you know these key items before you make the purchase. The third thing is the rules of delivery and passing of risk. Now, across Europe, a trader will have 30 days from the date of signing the contract or the formation of the contract online in which to deliver the goods to the consumer. If the trader fails to comply with this 30-day period, the consumer can provide a remedy period, and if the trader still fails to deliver, the consumer can cancel the contract. Again, this is an important change because there was certainly no maximum period under most European countries' laws before this. The fourth thing is the harmonised rule on refunds. What this means is that if a consumer cancels a contract in Europe, it will have 14 days in which it should receive a refund. Again, previously there were no uniform rules in any of the European member states, but now if a consumer cancels the contract, it will have a 14-day period for the refund. The fifth key change is to do with digital content. What the law will require is clear information at the point of sale. For example, details about the compatibility with hardware and software, and to reinforce the limitations on consumers making copies. This new change will apply, for example, to videos, games and music downloads. Then going on to the sixth point is strictly to do with online sales, and the directive means consumers have a right to refuse to pay if it is not properly informed of the price before a purchase is made. And the Commission has said that online auction sites must meet standard information obligations in order to comply with the new laws. The seventh change, which is will be of great interest to consumers, is the ban on pre-ticked boxes on websites. As you may have experienced, a number of websites have a system where when you purchase something such as a holiday, car hire and insurance and a number of other things are automatically included in the package, and you have to untick them in order for them not to apply to your purchase. Under the new laws, this will be illegal and consumers will have to choose exactly what they want, and any default mechanisms will not be allowed. The eighth change, again, which is very topical, is a new law on charges when you use a debit or credit card. Under the new change in the law, traders can only pass on the actual costs that they experience themselves when processing a credit card transaction. Previously, some traders have charged up to €10 for someone using a credit or debit card to purchase a product or perhaps a flight or an element of travel. Now they can only pass on their actual costs when the laws are changed. And finally, number 9, pressure selling measures will be increased. Now any sales made away from the trader's place of business will be subject to the consumer laws. This used to only include doorstep sales, but will now include sales made at sports grounds, on the street or in shopping malls, to ensure that consumers are protected where the trader is acting outside of its usual business premises. In conclusion, there are 3 final points. The directive will have significant implications for businesses and consumers across the 27 member states of Europe. Businesses should start reviewing their sales practices now, as the 2 years will pass very quickly, upon which they will have to comply with these new laws. And finally, some countries are going to be taking further steps, and for example in the UK there is a Consumer Bill of Rights which will go even further to protect the consumers. So in each country, businesses should also be aware of their national laws and any greater protection that might be given to consumers. Thank you very much for listening. If you have any further comments or questions, please feel free to contact me at my contact details, which will be shown now.